For the first time in history, the Supreme Court of Nigeria is set to attain its full complement of 21 justices following the recommendation of 11 justices to President Bola Tinubu for appointment. Among these recommended by the National Judicial Council, NJC, are 2 justices who sat on the 2023 Presidential Election Petition Court, Justice Haruna Samani and Justice Stephen Ada. A statement from NJC said the recommended justices had emerged successful from the Council's interview committee. 22 justices were initially shortlisted to fill vacant positions on the bench of the Apex Court, which recently reduced to 10 justices, its lowest ever. The last time the court got close to achieving its full complement was in 2020, when 8 justices were elevated from the Court of Appeal to join 12 other justices on the bench of the Apex Court. However, owing to retirement and deaths, the bench in the last 3 years continued to experience depletion, raising serious concerns among litigants and Nigerians in general. The statement signed by NJC's Director of Information, Mr. Sojioye, listed the other recommended justices as Justice Jumai Sankey, Justice Chiebere Uwa, Justice Chioma Nwosu-Eheme, Justice Moore Adumain, and Justice Obandi Ogunya. Others were Justice Habib Abiru, Justice Jamilu Tukur, Justice Abubakar Umar, and Justice Mohammed Idris. All right, Dr. Bati, we've talked about the justices and state of the Supreme Court justices in terms of their numbers in recent times. So this appears to be good news. Your take on this?
Okay, yes, good news in terms of the significance, the importance of the appointments. And this is the background. It should be recalled that before now, many Nigerians were complaining about the number of justices on the Supreme Court bench. Currently, we have just 10 justices on the Supreme Court bench. And that means that those 10 justices are overworked, overburdened. And in fact, as the president of the Nigerian Bar Association had pointed out in an intervention, they are also grossly underpaid and under-resourced. So now that, we have the full complement as required by the Constitution of 21. The last time we got close to that was in 2020, when 8 justices of the Court of Appeal were upgraded to the Supreme Court bench, giving us 20. But since 2020, we have had issues with resignations, with retirements, with deaths. Justice Amina Ogi, for example, retired. Justice Mohammed Datijo, for example, retired. Justice Cletus Nweze, God bless his memory, died. So for reasons of deaths, resignations, retirements, the number consistently went down. And interested parties started saying the NJC and the Judicial Service Commission should make new appointments. Now, under President Buhari, that talk was up in the air. A committee was set up to make recommendations. But at the opening of the legal year, 23-24 legal year, Justice Olukayode Ariwola had promised that, part of his attempt to leave a legacy behind, because he will be retiring next year, is to ensure that under his watch, that the full complement of the Supreme Court bench is achieved. And that's precisely what he has done. So as chairman of the FJSC and chairman of the Judicial Council, NJC, National Judicial Council, he has kept that promise. Now, there was a recommendation from the FJSC of 22 justices from different geopolitical zones. Out of the 22, 11 justices representing the various geopolitical zones have made the mark. And so now, upon the swearing in, we will have up to the full complement of 21 justices for the first time in a very long time. However, what are the issues? Number one issue here is that, look, it means that now that the Supreme Court will have a full complement, that cases can be heard more expeditiously. Panels can be constituted. The Supreme Court will not be overburdened. We will have, justices will also have lower, cases that they have to deal with, because people have been saying too much delay because the Supreme Court is grossly overburdened because of the reduction in number. So we'll see a Supreme Court that's likely to become more efficient. I also hope that now that we have the full complement of 21 justices, or after they've been sworn in, that the Supreme Court will further modernize. Their lordships still write longhand. They still write longhand, and this is the age of artificial intelligence, the age of computer and all that. There must be training for their lordships, so that they can use computers, so that their aides can use computers, so that, all of this would guarantee greater efficiency. This longhand writing is something antediluvian. Number two, part of the advocacy has been that, look, appointments to the Supreme Court bench should include academics, should include practicing lawyers. There were recommendations that persons like, Lisa Agbakoba, like Chief Wole, Olanipekun, SAN, are persons who are qualified to sit on the Supreme Court bench of Nigeria. But that recommendation was ignored. There are persons who have argued that, look, after a fashion in other jurisdictions, academics, distinguished academics, should be on the Supreme Court bench. After all, Teslim Elias, Justice Teslim Elias, got to the Supreme Court as an academic, one of the foremost authorities on the law of real property in Nigeria, popularly called land law. Justice Alexander Danley, QC, also had a PhD. These were academics who got to that bench. And the advocacy is for us to have the kind of situation they have in Canada, where there will be a diversity of opinion from people who have practiced, from people who are academics, and not to have a Supreme Court that is like a civil service structure, whereby you just get procedurally, promoted from Court of Appeal to the Supreme Court as if this is a civil service appointment. No, it's not a civil service appointment. In the light of the need to develop our jurisprudence further, we need that diversity. That, I think, is the other point that we need to worry about going forward. But as for ensuring greater efficiency, the details are out there. Everybody knows that. Pure common sense should determine that. Now, the other issue is that the NJC has also approved the appointment of judges of heads of courts, high court judges, heads of courts at the state level, heads of the customary court of appeal in the states, heads of the Sharia court of appeal in the states. All of these, of course, will be subject to approval by state governors at that level, and also by the state houses of assembly. And the appointments of the Supreme Court justices will also need the endorsement of the president, but after a fashion, because of the principles of the separation of powers. Nobody is likely to challenge a decision that has been taken by the National Judicial Council. The final point to make is that these new appointees should be reminded of what the principles are. Well, they don't need to be reminded. I'm not in a position to remind them. But for purposes of analysis, we have to say that, as Justice Ariwola himself pointed out at the opening of the new legal year, justices are expected to be above board. They will be taking their positions on the bench in the various jurisdictions at a time when Nigerians are a bit skeptical about the Nigerian judiciary. And so much is expected from them. Particularly, people will be watching those justices, that are moving from the Court of Appeal and who were part of the presidential election petition panel. And they'll also be watching, those justices who were responsible for certain contradictions that may have arisen from the fact that the Supreme Court bench, the Court of Appeal, the Nigerian judiciary is here to modernize and embrace the age of technology, writing longhand. When they write their judgments longhand, they give to people to type. Some of those people will go and type whatever, and they won't have enough time to look at it, and so you have issues. This is the age of technology. We should modernize the judiciary. That's the remaining legacy that Justice Olukayode Ariwola, with due respect, should think of leaving behind.
Right, just little to add, excellent and very detailed analysis from Dr. Abati there. I just say that this is welcome development that I had mentioned earlier on, and the significance of this is that during the retirement of Justice Amina Orgi, she had highlighted the fact that the justices of the Supreme Court were overburdened because of the fact that they didn't have the full complement as constitutionally provided for. And so the recommendation, Justice Olukayede Ariwola, the Chief Justice of the Federation of Nigeria, had said that he was going to, as part of his legacy, ensure that there was a full complement of justices at the Supreme Court. As we speak, there are cases that have been backdated since 2006, at least 2006, over 6,800 cases still pending at the Supreme Court. And so this will certainly expedite those cases being attended to. In its original jurisdiction on constitutional subject matters, the court is constituted of 7 justices. This means that in its current state with 10 justices, they could only take at one sitting just one. But now, with a full complement at 21, they could sit 3 or attend to 3 cases at the same time. So this is certainly welcome development. There's still issues around independence of the judiciary, which perhaps the CJN might want to look into as part of his legacy during his tenure. Also, the agitations raised earlier by Justice Mohammed, who had talked about the diversity of the makeup of the Supreme Court, the independence, the absolute power vested on the CJN himself, and to see how this will strengthen the institution of the judiciary in Nigeria. It's come up a number of times, especially post-election petition matters, and hopefully these are areas that can be looked into, but certainly great to see that hopefully it would ensure that there's more efficiency with regards to attending to court matters, especially at the Supreme Court.